The appeal lodged by 4 civil society organizations from Kenya, Uganda and Tanzania challenges a previous ruling in favor of the East African crude oil pipelines construction. This was the first time a panel of 5 judges from the Appellate Division of the East African Court of Justice was hearing the case nearly a year after it was filed. However, the session was adjourned when Tanzanian government lawyers pointed out that the appellants had failed to submit the necessary records from the lower court.
We felt that before the court hears the parties, they need to make an informed decision. And how do they do that? Is to ensure that all the documents are available. There are issues that were raised and form part of the appeal that could not be resolved unless you get those records.
In response, the appellant's legal team requested additional time to file the missing documents
at the council. So eventually the court acceded to our request for a 2-week reprieve or time to be able to file the supplementary record of appeal, and the court gave us up to gave the appellants up to 29th of November 2024 to file the supplementary record, and from there the court will schedule the date that it will be when the appeal will come for hearing.
The judges granted a 2-week extension, though they expressed concern over the cost and inconvenience caused to those who had traveled to attend the hearing.
They forget file documents, people have traveled from far, a very high cost, and a very easily say, let us adjourn for 2 weeks. You realize how much that costs both the court and the people who are here because of flimsy work by lawyers. Who bears that cost? Who should bear?
The council, like the appellants, filing the record of appeal incomplete. 6 of them or 7 of them, no one discovered that record of appeal is incomplete since last year. Even the Attorney General of Tanzania discovered it today. You can imagine the Attorney General of Tanzania discovered this defective, this incompleteness today. So I think it's a possibility shared. This is why we say let us do this housekeeping. It's equality for justice.
Several project-affected persons from Lake Albert region expressed frustration with the adjournment.
It's very unfortunately that today we are so excited, expecting to hear the case, but it's unfortunately that you have traveled all along away from Uganda, but you have not had a case, that some of the documents were missing, but somehow, somewhere, we are disappointed.
I have hope because this president of the court has given me a lot of hope.
The appellants accused the states of using technicalities to delay the case, arguing that the missing documents could have been addressed before hearing date was set.
We are wondering why the Tanzanian government and all the lawyers who are seated here, who have been seated on this case for 12 months, they could not raise this, and now they are raising it after 12 months. Of course, we know some of these governments are deliberately trying to frustrate the people who came to this court.
The appeal stems from a case dismissed by the First Court of Instance, which ruled the petition was filed too late. The appellants, 4 civil society organizations from Kenya, Uganda and Tanzania, are seeking to halt the 1,443-kilometer East African crude oil pipeline, citing human rights violations such as forced evictions, assault and environmental concerns. They argue that the pipeline's route through sensitive ecosystems, including wetlands and lakes, poses significant risks. Jackson Onyango, NTV, in Arusha, Tanzania.